Hi, today we will present about incorporation of a company. First of all, my name is Farah Shafika binti Al-Idrus. My matrix number is 05D1822F1015, and this is my group member. First, Nur Siti Aisyah, Masna Azilia, and Dayang Rashika Wida. For the first question, I will be present about the document required in forming a company in Malaysia. First, you need to submit filed forms PNA 42. Second, you need to have particular of registered office address. That is the company most recent registered address and change of registered address information. Third, you need to have certificate of incorporation of a company. Fourth, you need to have company profile, such as company name, company number, incorporation date, company type, company status, registered address, and business address. Lastly, you need to have a copy of the company name approval document issued by SSM. Secondly, this is an example of the relevant document from SSM website. This is a company name approval form PNA 42. Begin by submitting an application for company name approval to the Companies Commission of Malaysia, SSM. They will check for name availability and suitability. Second, this is certificate of incorporation of a company. Under the Companies Act 2016, a notice of incorporation of a company will be issued to the customer after incorporation. However, a certificate of incorporation of a company can be supplied if it is requested by the customer. Third, this is a particular of change of company name. Under the Companies Act 2016, a notice to certify the change of company name will be issued to the customer after the changes have been made. However, a certificate of change of company name can be supplied if it is requested by the customer. Lastly, this is attestation of company good standing, SCGS. SCGS is a document issued by SSM to confirm the existence of a company and that it has met the statutory requirement by the Companies Act 2016. These are the criteria for the requirement of SCGS to a company. First, the company has been incorporated for at least 18 months from the date of the SCGS. The company has lodged its latest annual return and audit financial statements or its latest exempt private company certificates. The company's status is existing and is not in the process of being wound or struck off or dissolved. The company has a registered address or its director do not have any outstanding compound with SSM. The company or its directors do not have pending prosecution case with SSM.
There are 10 relevant steps to register a company using MyCoID. Step 1. Choose a business structure. Decide on the type of company you want to register, such as a sole proprietorship, partnership, limited liability partnership, private limited company Sdn Berhad, or public limited company Berhad. Step 2. Business name search. Check the availability of your chosen business name with the Companies Commission of Malaysia, SSM. Step 3. Company name reservation. Reserve your chosen business name with SSM. Step 4. Prepare documents. Prepare the necessary documents including the memorandum and articles of association for Sdn Berhad companies. Step 5. Register with SSM. Submit the required documents and forms to the Companies Commission of Malaysia, SSM, and pay the registration fees. Step 6. Obtain business license and permits. Depending on your business activities, you may need specific license or permits from relevant authorities. Step 7. Tax registration. Register for taxes with the Inland Revenue Board of Malaysia, IRBM, to obtain a tax identification number. Step 8. Open a bank account. Open a business bank account to handle your company's finances separately from personal finances. 9. Compliance with labor laws. If you plan to hire employees, ensure compliance with labor laws and register with the Employees Provident Fund (EPF) and Social Security Organization (SOCSO). The last step is annual compliance. Comply with annual filing and reporting requirements such as filing annual returns and financial statements.
What is separate legal entity of a company law? Separate legal entity is when you and anyone involved in your company are separate from your business for legal purpose. Basically, and separate legal entity means that if someone takes legal action against your business, your personally finances are separate and safe from legal suit. And any investor, stakeholder, shareholder, and partners are also personally protected. But only certain business structures are legally separate from personal assets, including corporation, limited liability company, limited partnership. If your business is an separate legal entity, you have personal liability protection. Examples of personal protection include: first, individual or business cannot hold shareholder liable for business action. Second, separation of business and personal accounting and asset. Third, creditors cannot seek repayment from or take action against shareholder.
Transfer his business of bootmaking, initially run as a sole proprietorship, to a company, Solomon Limited, incorporated with members comprising of himself and his family. The price for such transfer was paid to Solomon by way of shares and debentures having a floating charge security against debt on the asset of the company. Later, when the company's business failed and it went into liquidation, Solomon's right of recovery, secured through floating charge against the debentures, stood a prior to the claims of unsecured creditors, who would thus have recovered nothing from the liquidation proceeds. To avoid such alleged unjust exclusion, the liquidator, on behalf of the unsecured creditors, alleged that the company was essentially an agent of Solomon, and therefore Solomon, being the principal, was personally liable for its debt. In other words, the liquidator sought to overlook the separate personality of Solomon Limited, distinct from its member Solomon, so as to make Solomon personally liable for the company's debt as if he continued to conduct the business as a sole trader. The judgment in this case is the Court of Appeal declared the company to be a myth, reasoned that Solomon had incorporated the company contrary to the true intent of the then Companies Act 1862, hereinafter to be referred to as the Act, and that the company had conducted the business as an agent of Solomon, who should therefore be responsible for the debt incurred in the course of such agency. However, upon appeal, the House of Lords reversed the above ruling and unanimously held that as the company was duly incorporated, it is an independent person with its rights and liabilities appropriate to itself, and that the motive of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. In the present case, the Company Act of 1862 provided that any 7 or more persons associated for a lawful purpose may, by subscribing their names to a memorandum of association and otherwise complying with the provision of the Act in respect of registration, form a company with or without limited liability. The Act further provided that no subscriber shall take less than 1 share, that there were 7 actual living persons who held shares in the company was never doubt, whether the capital of the company is owned by 7 persons in equal share with the right to equal share in profit, or whether it is almost owned by 1 person who takes practically the whole profit. It does not concern a creditor of the company. The company does not lose its identity if the bulk of its capital is held by 1 person. The company at law is an altogether different person from its subscriber or shareholders. Since the company fulfilled all the requirements of the Act, the court held that the company had been validly formed and was a real company.